Well, you didn't save any time, but we'll give you 2 minutes anyway.
I appreciate that, Your Honor.
May it please the court, my name is Theodore Olson. I'm here on behalf of the plaintiffs. It is important to focus on the fundamental fact that California has engraved discrimination on the basis of sex and sexual orientation into its fundamental governing charter. The label given to Proposition 8 in the official voters' pamphlet said it all. It eliminates the right of same-sex couples to marry. This proposition marginalized and stripped over 1 million gay and lesbian Californians of access to what the Supreme Court of the United States has repeatedly characterized as the most important relation in life.
Mr. Olson, then, you do think there's a difference between taking the right away and not affording it in the first place?
Yes, we do, Judge Reinhardt. That is what the United States Supreme Court said in a case going back to Reitman versus Mulkey in 1964, where the California citizens acted through this process and took away rights with respect to discrimination in housing. And that is what the Supreme Court said in Romer versus Colorado, that it does make a difference. Now, I don't think, as an original matter, that it would be constitutional if Congress had enacted Proposition 8 5 years ago, before the in-re marriage cases, but I think it makes it worse. And that's what the United States Supreme Court has said. The taking away of the rights in that context enhances the effect of the Constitution, of the purported constitutional change.
Well, what's your answer to a case that Mr. Cooper referred to several times? It's the one about the it was busing and other methods of bringing diversity to the schools.
That's the Crawford case.
Yes.
And what the Crawford case did was say that to the extent not required by the Constitution, remedies for constitutional violations could be restricted by the people of the state of California. But that doesn't change anything. I heard Mr. Cooper mention the Crawford case 5 times. Not once in anywhere in the Crawford case does it suggest that an initiative measure somehow rises above the 14th Amendment to the Constitution of the United States. And that's certainly what the Reitman case held, and that's certainly what the Romer case.
Are you suggesting then that a gay marriage is required by the Constitution of the United States?
What is required by the Constitution of the United States is the fundamental right of its citizens to marry. Now, Mr. Cooper defined that as it has always been between a man and a woman, but the United States Supreme Court has never said that. What the United States Supreme Court has said in 14 cases involving the right to marriage, in the context of abortion, in the context of prisoners, in the context of contraception, and in the context of divorce, that the right to marry is an aspect of the right to liberty, privacy, association, and identity.
What I'm trying to find out is your argument here in response to Crawford that there is a constitutional right to gay marriage. Do we have to reach that point? Because what you're answering is that they are taking away a constitutional right. And if that's your answer, fine. If not, I'd like to know that also.
No, my answer is that they are taking away a constitutional right given by the state of California, recognized by the state of California. That in and of itself makes Proposition 8 unconstitutional under Romer and Reitman. But I would also say that it is also constitutional, and I would not call it, Judge Reinhardt, gay marriage, or I wouldn't call it single-sex marriage, any more than the Supreme Court of the United States called it interracial marriage. What the Supreme Court has said 14 times is that it's a right of liberty, association, privacy.
You can say whatever you want, but in deciding the case, I think we're entitled to know whether your answer to Crawford is that, yes, you can't take away a constitutional right, and this is taking away a constitutional right under the 14th Amendment.
Yes.
Okay.
I would
And
also say...
it's dependent on that?
Pardon me?
It's dependent on our finding that they would be taking away a constitution?
No, it is not, because I went on to say that the right to marriage is a right of an individual. And by the way, Mr. Cooper talks in terms of the right of society, society's interest in procreation. It is not society's right. The rights under the Constitution are not the rights of California. They're not the rights of voters of California. They're rights of citizens of the United States under the Bill of Rights in the 14th Amendment. And if California could insist that something to do with procreation be engraved onto the right of marriage, it could take that away. It could say, we're overpopulated, we don't want procreation, and we'll deny people the right to marry. This is a fundamental individual right, and what the Supreme Court said, and the reason I'm emphasizing this point, Judge Reinhardt, because if you look at it from the standpoint of a right of two particular individuals, maybe they were Mr. and Mrs. Loving in the Virginia case of an interracial marriage. It was marriage. It was their right to get together. And what the Supreme Court said in the Griswold case, we deal with a right of privacy older than the Bill of Rights. Marriage is a coming together for better or worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life and so forth. This is from the Griswold case, one of 14.
Mr. Olson, I'm not trying to express a view on gay marriage or any marriage at this point. I'm trying to find out how far we have to go if we are to accept your view of this case. Certainly, if we start out from the assumption that everybody is entitled to marry everybody else, regardless of sex, regardless of sexual orientation, if we have to reach that issue, we would. But as you well know, as you argued the Plout case, we are advised not to reach a constitutional question unless we have to. I was not planning on reaching that question to you this early in the discussion, but it seems to come in relation to how we deal with the Crawford case. And it was for that reason that I was asking you whether, in order to distinguish Crawford, you are saying that it's necessary to take the position that you can only, the only thing you can't take away as a state is a right under the 14th Amendment.
There seems to me there's two questions in that. How far you have to go and the significance of Crawford. You do not have to go any further than the Romer case requires you to go. The Romer case says taking away the constitutional right of individuals who are homosexuals because of their classification as homosexuals violates the United States Constitution, even under a rational basis test. And I would say, if I get a chance to do that, this is the clearest case I can imagine of heightened scrutiny. But in addition to that answer, which I submit is the answer to your question, how far do we have to go? But the additional answer with respect to the Crawford case is a completely separate thing, it seems to me, because Crawford was saying, yes, the citizens can change non-constitutionally required remedies for constitutional violations. That's different than this. And so for the Crawford case, in my judgment, has nothing to do with this case, and I would be happy to put the Crawford case against the Reitman case, the Romer case, the Loving case, and Lawrence versus Texas. It cannot possibly penetrate the full weight of those four decisions. And I guess one additional answer, and I think it's important since I slipped into mentioning the Lawrence case, the United States Supreme Court has determined that intimate sexual conduct between persons of the same sex is constitutionally protected. And the Supreme Court has said, as I said, marriage is a fundamental right. How can the fundamental right of marriage be taken away by Californians from persons because they're engaged in a constitutionally protected activity? How can the constitutional right be taken away because of the constitutionally protected activity? It cannot exist. If you put the Lawrence case together with the marriage cases, Loving case, and so on and so forth, you cannot take away that right, which is not a right of same-sex persons. It's a right of all citizens, and it's a right to be with the person that they love, to have an association that they select, to live a life of privacy, to identify themselves as a self-identification, as Justice Kennedy talked about in both Romer and Lawrence. That right cannot be taken away from individuals in this state because of their sexual orientation. It is discrimination on the basis of sex, and it's discrimination on the basis of sexual orientation. And if even under a rational basis test, the proponents of Proposition 8 cannot come up with a reason. They've tried various different reasons throughout the election campaign and this litigation with various different reasons. They started off with the proposition, and it's in the ballot materials, that it was necessary to protect our children from thinking that gay marriage was okay. That was the original rationalization for the statute that was in advertisements, and it's in the ballot measures submitted to the voters. Protect our children from thinking that gay marriage is okay. Well, what is the matter with that? It must be something about gay people that are getting married that would be disturbing to California voters, and you have to take that risk away from them. They basically retreated from that proposition, and it only appears on pages 107 and 108 of the brief that they filed. And basically they're now saying that it might, if gay marriage were permitted, this is what they say on page 107 or 108 or 109 of their brief. Proposition 8 needs to be enacted because the existence of same-sex marriage will somehow, they don't use the word somehow, will make children prematurely occupied with issues of sexuality. That is nonsense, that you can enact a proposition that walls off the citizens of this state from a fundamental right because you're worried that otherwise children might be prematurely preoccupied with issues of sexuality. That, of course, if that was a justification, it would equally warrant banning comic books, television, video games, and conversations with other children.
In deciding whether rational basis saves this proposition, what do we look to?
Well, whether I'm not sure your question is asking me whether it should be rational basis and what would be the justification.
Assume it's rational basis. Do we look to the record that was made in district court, or do the cases suggest to us that we imagine whether there is any conceivable rational basis and apply that?
It has to, the answer is that is too attenuated, just to imagine something from the sky that someone might conceivably imagine. And the City of Claiborne case and the Romer case makes it clear that, and then Justice Kennedy, in decision for the court in Romer case, says we must look further than that. We must look into the reasons, and they must make sense, and they can't be attenuated, and they can't be motivated by fear of people that we don't like or minorities. It's got to be more than that, and most of all, it has to be rational. And that's why I was looking through the reasons that they've advanced. One is this protect our children, and we've seen, at least I think it's manifestly clear, that that is not a rational basis, because you can't do that, because basically that's based upon the idea that there's something wrong with these people. We must protect our children from them. That won't work.
Suppose, and just assume this for the purpose of my question, that we were to conclude that this accidental pregnancy argument is in fact a rational basis. Have the proponents of the proposition or the imperial clerk given up that argument because of the arguments they made in the political process?